Chapter 8, Part 4 or 5, I believe. We finished up in the last part with talking about copyrights and the fair use doctrine on copyrights. And now we're going to talk about trade secrets. So trade secrets are information of a commercial value such as customer lists, plans, research and development, pricing information, marketing methods, and production techniques. This extends not only to ideas, but to also the expression of those ideas. Stealing confidential business data by industrial espionage is a violation of the law. It's theft of trade secrets unless you have a contractual arrangement. Common law generally protects these trade secrets, but states have also passed laws using the version of the Uniform Trade Secrets Act to protect trade secrets. Unfortunately, the development of technology has made it easier to steal or to acquire and misuse trade secrets. Dishonest employees can easily appropriate trade secrets via computer hardware, software, and social media. Alright, next subject is the Berne Convention, which is a treaty. Remember we talked about treaties earlier, and that treaties, when they're adopted by the Congress, become law of the United States, just like a statute. So every country that has signed the Berne Convention Treaty recognizes and authors copyrights, and no notice is required. So one exception with the Berne Convention that's been adopted by the European Union is the extension of musical protection from 50 years to 70 years. Another agreement is the TRIPS Agreement of 1994, which established standards for the international protection of intellectual property rights. Okay. Member nations have to ensure that legal procedures are available for parties who wish to bring actions for infringement. The TRIPS Agreement forbids member nations from giving their own citizens favorable treatment without offering the same treatment to nationals or other member countries. The Madrid Protocol is another area of law, and it allows a U.S. company to register its trademark abroad with one application. Doing so reduces the time and expense of securing international trademark protection. So instead of having to file with England, France, Spain, or whatever, you can file with under the Madrid Protocol and basically have a protected trademark in all of those countries. Okay, the Anti-Counterfeiting Trade Agreement, ACTA, was designed to combat global counterfeiting and piracy by increasing the cooperation between countries, facilitating best law enforcement practices, and providing a legal framework to combat counterfeiting and distribution of pirated copyright works. So countries that have joined in this agreement are required to establish border measures that allow officials on their own initiative to search commercial shipments of imports and exports for counterfeit goods. You can see by the number of laws that have been passed, and probably in the future what's going to happen, that this is a serious commercial issue, particularly in the United States. Again, because I would say historically we've been at the forefront in the consumer world in the production of inventions, copyrights, etc. And there are a lot of countries that are somewhat lawless, who are taking those inventions and making a profit off them in their own country, as well as trying to ship those products into the United States at a lesser cost And remember that to copy something probably and usually costs a lot less than it did for the inventor, and the time and energy and money put into inventing that object. Okay. The internet has also made it easier to steal or to violate, infringe upon people's intellectual property rights by enabling the transfer of information, whether it's protected or not, to large numbers of people. Domain names are unique and are registered. You can register it, but it has to be determined to not be in use already. You have to complete a form and pay a fee. The Electronic Communications Privacy Act makes interception of electronic communications a crime, provides for civil damages and criminal penalties. There are some permissible uses where there's access by a party or entity providing the service, or government or law enforcement entities acting within the law. Okay, an interesting law. When I first read this, I thought this was interesting because I'd never heard of it before, but it's been around now for a while. The Anti-Cybersquatting Consumer Protection Act. So how did this come about? Okay, well, criminals, and I'll refer to them as criminals, are very creative. And whenever there's something new in the world, there's always somebody who's out to figure out a way of cheating. And so that's what happened with domain names. So if, for example, you're a famous company like Coca-Cola, you certainly want your domain name to be something like Coke.com or Coca-Cola.com, or something like that. So what these, quote, criminals do is, for a nominal fee to get a domain name registered, they will register these important corporate or business names and then hold them hostage, so that Coca-Cola, for example, would have to buy it from this person who registered it. And these companies initially were paying literally thousands and millions of dollars because of the value of having that. Because if you go and type into your search something like Coke.com, your Coca-Cola company hopes you're going to get to their web page, not to some blank web page or some joke or something like that. So it takes away a sort of advertising mechanism. So Congress passed a law called the Anti-Cybersquatting Consumer Protection Act that makes it illegal to acquire a domain name for a famous corporation or business or whatever, with the intent to not use it properly but to sell it to that company. So the name has to be famous. You are registering it in bad faith, that is an intent to defraud, and the name is already a registered trademark. So hopefully this law can not only deter people from doing that, but also provides a remedy for businesses to get them to turn back over that domain to the person who has that registered trademark for that product. Okay, so as I said at the beginning, my knowledge of intellectual property is very limited. It's a very expert area. Perhaps if you want to know more, you can look at this video, which I recommend. Hopefully we've at least identified issues that you might run into in a business setting, so that you know, and it triggers in your mind, that red flag goes up and says, oops, I might have an intellectual property issue. I need to go talk to a lawyer or somebody who can help me with that issue. Alright, so that finishes Chapter 8. Again, the magic word for Chapter 8 is patent.